Good evening, friends. On a weekend, once you have knowledge sharing by a person like Geeta Luthra, a senior advocate, and additional advocate general Haryana, and one who has taken our sessions when we were beyond law CLC, we were in the baby steps of that. And her session on the land acquisition, during the baby steps, have taken the giant steps in this regard. And though we were connecting with Ma'am Geeta Luthra time and again, but as they say, things only take when they are destined to be. And we normally take sessions which are challenging and you have to juxtapose different aspects. Therefore, we thought, why not take a session on a criminal defamation vis-a-vis civil defamation? This aspect, normally of late, we have seen that there are a lot of allegations, counter allegations, a lot of threats, otherwise also, to the effect that you can be taken to the court for the defamation cause. What are the positions where they are to be taken together, and what are the facets where there are subtle distinctions between the two? In this regard, today's legal knowledge sharing by Ma'am Geeta Luthra would be giving her insights. So do stay connected with us. Those who have missed her previous webinar, they can always stay connected with us by liking, sharing, and subscribing to the Beyond Law CLC channels to take it to the peak of more than 500 webinars, which we have taken across. Being a weekend, we will not take much time. We request ma'am to share her knowledge. Over to you, ma'am.
Thank you. Thank you. It's actually a very interesting subject in today's time when criminal defamation has withstood the constitutionality test, when Justice Deepak Mishra, in fact, adjudicated upon the issue. And it was very interesting that Justice Mishra, the Chief Justice of India, in fact felt at the outset that criminal defamation should actually be abolished, and that it's been abolished in several countries. So why is it continuing in India? But then, while he heard arguments, and the case is entitled Subramaniam Swamy, because it was a case filed by Subramaniam Swamy in the case where he had made allegations against Jayalalitha, and there were two very interesting cases which arose from that. But what I'm saying is that the constitutionality test, even though initially in the first blush, Justice Deepak Mishra had felt that he would probably strike it down after hearing detailed arguments. And after reviewing the law and seeing that is civil defamation enough, the court felt, the Chief's Court, Court number 1 felt that no constitutionality test has been it will withstand a challenge to its constitutionality, and criminal defamation should remain on the statute book. There are many reasons for it, and I think the reasons are, in fact, particular to India, where averments are made by one leader against another, by one person against a public figure, whoever that public figure may be, against actors, against politicians, against, and sometimes even by journalists, very frequently by journalists. And therefore, it was felt that while civil defamation, which is a tortious liability, should continue, it was not an efficacious enough remedy, and criminal defamation must continue to be on the statute book under section 499 and 500 of the IPC. I begin this with a quote from Bhagavad Gita, which says, men will recount thy perpetual dishonor, and to one highly esteemed, dishonor exceeded death. So what is significant is that your reputation is so important and integral to you that even life itself may be less important than the ignominy of being defamed. And so, coming back to the Constitution Bench judgment, the Supreme Court, speaking through Justice Deepak Verma, said, reputations cannot be allowed to be sullied on the anvil of free speech, as free speech is not absolute. Right to life and freedom of speech have to be mutually respected. So let's look at this. You have on one hand Article 19, which shows you freedom of speech and expression. And you know how important it is for every democracy that truth should emerge. How important it is for every democracy to have every opinion, whether it be in the political sphere, whether it be in a farmer sphere, which has become important these days and is being discussed because of COVID having taken the whole world by storm. The fact is that truth and opinion must emerge, and it should be tested on an anvil where a person may be able to say what he would want. Now, it reminds me of a very recent notice by the Supreme Court, where Supreme Court has issued notice on a petition where someone has asked for damages for one of the COVID vaccines not being appropriate and having caused illness oblique death. So look at it from this perspective. You want every viewpoint to be tested on the anvil of arguments, of counter arguments, and then to have truth emerge. So that's Article 19, which is fundamental to the Constitution of India, to our fundamental rights, is on one hand, what is very important. On the other hand, it is important also that a person's reputation be not besmirched. And for that, you have Article 21, which is your right of life. If I don't have my reputation, if I don't have my respect, if I don't have the name that I have taken years of toil and hard work to create, if I don't, for example, you are known for your honesty, or you stand by your honesty and integrity, you stand by a fact that you are not a thief, then if that is sullied, question is not your very right of life under Article 21 brought into disrepute? And that's why you have to look. There are two aspects of it. There is right to one's reputation, but there is also a right of freedom of speech and expression. And right to one's reputation has precedence over the right to freedom of speech and expression. One cannot say anything without thinking what are the repercussions on the person against whom these allegations are being made. And that's what is fundamental with regard to defamation, whether it be civil or criminal. Of course, we'll go into the distinction in a minute between civil and criminal defamation and whether both can coexist, whether both can be filed or should not be filed. And if you see some of the most significant or recent cases over the last 10 years, you would see cases of defamation filed between Mr. Gadkari, who was a minister, who is a minister, and Mr. Arvind Kejriwal, the chief minister of Delhi. You have cases between Subramaniam Swamy and Ram Jethmalani, which is one of the salient judgments on civil defamation. You have cases where Mr. Arun Jaitley had filed, where the issue of civil versus criminal defamation came up. You have cases where Mr. Subramaniam Swamy made allegations, and you have the entire field of international law where there have been cases of defamation, civil and criminal. The emphasis over the years now in the US and in the UK has been on civil defamation, but the fact is that in those countries, your tortious liability is highly developed, and the tortious liability results in huge damages, which in India it does not. And that is why when you look at defamation, you have to see how quick is the remedy. There is no point my succeeding in a civil defamation case after 20 years when the person is almost dead and buried. The relief and the remedy has to be soon. The delay in any remedy of this nature makes it almost infructuous and not worthwhile. There is no point filing a petition if you are not able to at least get redressal in a court of law. And that's why criminal defamation, one of the reasons why criminal defamation has been allowed to continue on the statute book. I begin with a quote from the book, from the judgment of Subramaniam Swamy versus Union of India, where there are paras and paras which are devoted to the fact that it is the most fundamental of rights, and it is a right which cannot brook any delay. So one of the aspects that would come out is a citation which I will give, which is where the court's Justice Deepak Mishra's judgment says that criminal defamation is one case where you will get redressal. It notes the arguments of various learned counsels and then finally comes to this finding that we cannot not have the criminal defamation in the statute book. Now, very recently, we've had some very interesting cases, and I will come to the various exceptions of criminal defamation in a bit, because that would make it just only simply very technical. One, we must remember that criminal defamation is a defamation made of a person or a class of persons by a person who will be an aggrieved person. And so in the course of today's talk, I will define what is an aggrieved person. It is made against a class or against a person. It can be through an innuendo. So what is an innuendo and what should be the effect? The effect should be it lowers the reputation of that person in the eyes of right-thinking members of society. And who would be considered a right-thinking member of society? That has been said very beautifully by a judgment by Lord Reed in England in Lewis versus Daily Telegraph. And I'm going to quote you a para, which I think is pertinent. He says it repeatedly in that judgment. It's one of the parent judgments which even Indian courts have cited. There is no doubt that in actions for libel, and the difference is there are two actions in criminal defamation, libel and slander. Now, libel is the written word, slander is the oral word. Both cause the same amount of damage. There is no doubt that in actions for libel, the question is what the words will convey to the ordinary man. It is not one of construction in the legal sense. The ordinary man does not live in an ivory tower. He is not inhibited by a knowledge of the rules of construction. So he can and does read between the lines in the light of his general knowledge and experience of worldly affairs. A man who wants to talk at large about smoke may have to pick his words very carefully if he wants to exclude the suggestion that there is also a fire, but it can be done. What the ordinary man would infer without special knowledge has generally been called the natural and ordinary of the words. But that expression is misleading in what it conceals the fact that there are two elements in it. Now, the question arose was that a person said, this person is a scoundrel, and it went on, he's a scoundrel, he's bad, etc., generic words, and he is also a thief. So the question was, did thief being per se defamatory, does thief relate back to generic words? Ye chor hai. So do you mean he is actually a thief, or are you just doing a passing off of a very bland statement? So the courts have said, the court came down and said, when you say he's also a thief, that word is per se defamatory. And it was further in the same context, one other sentence which was used, ordinary men and women have different temperament and outlooks. Some are unusually suspicious, some are unusually naive. One must try to envisage people between these two extremes and see what is most damaging meaning that they put to the words in question. So we have to see the rational common man. We can't see somebody who's extremely suspicious. We can't see somebody who is not. Now you have one of the essential ingredients in defamation or a complaint of defamation. And it's important to note that defamation is non-cognizable and it is bailable. One of the odd aspects which is most important is it has lowered my reputation or the reputation of the person who is aggrieved by it in the eyes of right-thinking members of society. So you would normally need one or two right-thinking members of society who would come and say that the reputation has been lowered in our eyes. Very recently, in fact, I was doing one matter of an MNC who is based out of the US, where this aspect came up. And this averment was missing. And the court held that criminal defamation cannot be made without this essential ingredient of showing that in the eyes of right-thinking members of society, the reputation of the person has been lowered. This is part of explanation 4 and is very important aspect. And I'll perhaps share with you a judgment, if time permits, on this. Now, who can file the complaint? Let's look at who can file a complaint. An aggrieved person can file a complaint. An aggrieved person can even be a company that has a reputation. Now, who can be an aggrieved person? Aggrieved person is a person whose reputation may be sullied. Suppose it is but he has to still prove that he is an aggrieved person. Even if it is about the reputation of a person, that person is under a duty to show that he is an aggrieved person, that he is harmed or it has resulted in harm to him. So he has to be an aggrieved person. Very recently, in fact, 2 cases come to my mind. An advocate filed a petition in one of the trial courts before the magistrate in Delhi. And he said that the person who had made allegations against him in business standard, where it were not against him, against RSS in general, had said that various things which were unpalatable. And the exact words which were used was that members of RSS are oppressive to Indians, mentally disturbed, disrespectful of the Indian national symbols, etc. Now, the person who was the complainant was not being able to show that he was the aggrieved person. So a statement was made that he was aggrieved because he was a member of RSS, but he did not bring any evidence forth to show. So, and various allegations made by him and complaint filed by him was held to be not maintainable by a single judge of the Delhi court, saying that this is an advocate who has filed the complaint, and this advocate has no locus standi because he's not been able to prove or establish that he's an aggrieved person. In similar facts, if you recall a very recent movie that has been shown called Gangubhai, that in that movie, a person claiming to be the adoptive son of Gangubhai claimed that that the movie was, even though Gangubhai was deceased, that being an adopted son, he was hurt, and it was a defamatory of his adoptive mother, because he said on whose life they had said that she'd been a prostitute, etc. And all those aspects came up. Several councils, there was a barrage of lawyers for the filmmakers, and the film was sought to be banned. And Bombay High Court had refused the reliefs of interim, of any interim relief. The film was based and has been a very famous film on the Mafia Queens, based on the book, The Mafia Queens of Bombay. The court, speaking through Justice Indra Banerjee and Justice D.K. Maheshwari, said that he has not been able to show that he's an aggrieved person. There was an argument made that perhaps she would have wanted all this to come out. In any case, he had no locus standi. He was not an aggrieved person. He couldn't show that he was the adopted son. And in any case, it was done as an artist to show a story in terms of a film, and he did not succeed in the Supreme Court. So this is one aspect, that a person has to be able to show that he is an aggrieved person under Section 198. And some of the judgments on this aspect are these judgments. Now, coming to various interesting and perhaps anecdotal cases, I would first want to tell you the difference and what the Delhi High Court said about civil defamation and criminal defamation in the case of Mr. Arun Jaitley, where both civil defamation and criminal defamation were filed. In that, he was one of the union ministers, if you recall, and a very popular union minister at that. And what was held was that a civil suit filed by the respondent and the criminal complaint were based on the same facts, and the criminal proceedings could possibly be stayed under 309(2) on that ground. Then, and that if both continued simultaneously, and one judgment would be by a civil court and another judgment by a magistrate, and therefore the reliance was placed on a judgment again called Radhe Shyam Kejriwal, which is a well-known judgment on this, that the standard of proof in a criminal case is much higher than in a civil case, and the court held with the petitioners. But in that case, finally an apology was given and the matter was closed. What is innuendo. An innuendo is when you don't say something directly, but you know that it is targeting a particular individual. How do you target that individual, and how do you do an innuendo against an individual who you don't name, but you make it abundantly clear that, for example, I am talking about someone who takes care of the government X portfolio, but whom I'm not going to name, or you say something defining something, an actor or actress, a role that they may have played, where you understand that this is the role of X film by X actor or X actress. And therefore, you know that that innuendo is targeting X, but it doesn't name X. That is an innuendo. And innuendo is as dangerous and as liable under civil and criminal defamation as is a direct statement blaming the person. Now, there are some things, having said defined innuendo, I want to say there are some things which are per se defamatory. It is the same example, for example, where somebody said, so you are a thief. It is per se defamatory. You don't, there is a presumption unless the person can come within an exception. And in criminal law, for example, it is not enough that it is the truth. It also has to be for public good and in good faith. And I will show the definition of criminal defamation and the exceptions to illustrate this point. But speaking on per se defamation, suppose you say a person is a gunda, a person is a rapist. These are per se defamatory. And on this aspect of saying gunda, the matter was tested in a court of law, and the court has held in the Indian context that calling a person per se gunda is by itself defamatory and per se defamatory. I'll just come back to the exceptions. Now I want to just say this. What if you say that I have only repeated what Johnny said, or what Tom said, or what X said? Is that defamation, or will it be a defense to say, I have only published whatever Tommy said? Yes, I did report it in my newspaper, but I only copied newspaper, which is a national journal, which had said it. So I have, mine is just a good faith. The courts have held, sorry, this is not permissible. Because repeating without verifying and without ascertaining is as harmful, as dangerous, as punitive as saying it in the first place. And there is an extremely well-known judgment on this issue. Now, coming to the definition of defamation, criminal defamation, because that's what will be relevant when people take a defense. And normally it is for the prosecution to prove its case. So in every case, it is for the prosecution. The burden of proof is on the prosecution. But in defamation, the moment the prosecution, that is the complainant in defamation cases, is able to establish there is a prima facie ground where someone's been called dishonest or any imputation, whether immoral or inhuman or violent or doing acts of domestic violence, doing acts of sexual abuse, doing acts of domestic abuse is made, it's per se defamatory. That person has discharged his onus. Then the onus switches on the accused. And that there are several judgments that the onus is on the accused. I believe some of them are Chaman Lal, Harbhajan, etc. They are lead judgments on this issue. But I would not be fair if I do not read to you the definition of criminal defamation as provided under 499. Whoever by words either spoken or intended to be read, or by signs or by visible representation, makes or publishes any imputation concerning any person intending to harm or knowing or having reason to believe such imputation will harm the reputation of such person, is said, except in cases hereinafter accepted, to defame that person. I have already given you an example of explanation for and what is required, that you have to show that it has lowered the reputation or the esteem of that person in the eyes of right-thinking members of society. But what I want you to look at is perhaps first exception, ninth exception, and 10th exception, for which I will have to read those out to you. Imputation of truth which public good requires to be made or published. It is not defamation to impute anything which is true if it be for the public good. So truth alone is not enough. Truth has to be accompanied with public good. And in this, I will refer to the case of the famous R.K. Karanjia. I will just come to it, where the Blitz published a piece, and I'll just come to it. Now, I just want you to look at the other two exceptions, which I believe are very important. Imputation made in good faith by a person for protection or his or others' interest. It is not defamation to make an imputation on the character of another, provided that the imputation be made in good faith for the protection of the interest of the person making it, or of any other person, or for public good. So you have to explain how was their good faith, how was their public good. And the last 10th exception, caution intended for good of person to whom conveyed or for public good. It is not defamation to convey a caution in good faith to one person against another, provided that such caution be intended for the good of the person to whom it is conveyed, or of some person in whom that person is interested, or the public good. Now, these are important exceptions. The test is very vigorous, and the test has to be satisfied by the accused by showing that what the accused has said is for public good. There is an important aspect to it, and that is limitation. The test of limitation is very important. It cannot be that you may make allegations at any period of time. So limitation as such, in terms of the offense itself, cannot permit making allegations which are jaded or which have lost time, because ultimately the person who makes those allegations has to make sure that that he can prove those allegations. And with time, you can't prove those allegations. And therefore, insofar as the person who files defamation, he has also to ensure that he files or she files their complaint forthwith soon, so that it is both, so that there is evidence. Now, I would be remiss if I don't give you certain interesting cases before I close. But before I do that, I want to refer to a line, an aspect that has come up, which is the Metoo movement. The Metoo movement, which came up with regard to Weinstein, took the world by storm, and many people came and made complaints and allegations. And those complaints and allegations were made in social media without any evidence with regard to alleged allegations which were absolutely stale. I'm not talking of truth or untruth, but if you have to do a fair trial, there has to be a time-bound complaint, a time-bound allegation. And we are living in the world of social media. So talking about civil defamation, talking about criminal defamation, I would be totally remiss if I don't say that social media will have to be cautious and should be cautious in what they say, which may be a casual statement, which may take fire from one to another and sully and harm the reputation of a person who has built it over the years. And it is in today's day that we have to be very careful how we repeat what another person has said. Every person who repeats an act is equally liable as the person who initiates. As was said in that famous case of Lewis, you may be saying there's smoke, but are you saying there's a fire? Otherwise, if there is a presumption there's a fire, you will be liable for defamation. That is the test, and that test has to be looked at very carefully. Now, I first go to the Karanjia case, and that what had happened was that there was a lady called, I think, Mrs. Shukla, who during emergency was jailed. And while she was jailed and came out, after she came out, an article came out in the Blitz that she had become pregnant with one of the other people who was in jail at the same time, trying to show her immorality as well as the other person's immorality. And a case was filed, which is a well-known case which was lost by Mr. R.K. Karanjia because it was not a statement made for public good or made necessarily in good faith. It was just gossip, and it was harming two people's reputation and life. So I was referring to this in also the context that journalists may believe that in order to arrive at the truth, they need investigative journalism. They can make any statements, and the statements may not be supported with hard facts by merely saying we have a source. Now, source does not need to be disclosed, except when the court wants to test it in a defamation case. But ultimately, it has to be a solid source. You cannot sully a person's reputation in the name of investigative journalism. And the Supreme Court, in several judgments, in PUCL versus State of Maharashtra, the Delhi High Court, in India's Daughter, all these have held that when a matter is sub judice, please just report what is happening in the matter and don't convict the person in the eyes of the public even before he is convicted in a court of law. Public opinion, newspaper opinion does affect, and therefore does have an effect on the minds of those who are deciding and on the minds of the public, and may not be fair to the person. Now, since I have a paucity of time, I wanted to give 2-3 interesting examples and cases. One was a very recent case, which I thought was very interesting. Johnny Depp and against Heard. And what had happened in that case was that she filed a case against him on the ground of domestic violence, or she complained, sorry, she didn't file a case. She just made an averment that he had been guilty of domestic violence. And he filed a defamation case. In the meantime, the counsel said, his counsel also said something, and she filed a case against him. But she was unable to prove her allegations, which were made only in the public sphere and in the social sphere. And Mr. Depp was given $15 million as compensation and punitive damages. She herself, Amber, was given $2 million in damages by the jury. Interesting case. We hear all the time of match fixing. And you know that in India, there have been these cases which went on in courts of law of with regard to match fixing. One of the interesting cases was by a cricketer who was accused by Lalit Modi to match fix in the IPL, Chris Cairns. And in that case, the court held him liable when he sued for defamation. Chris Cairns sued Lalit Modi. Damages were awarded, if I recall correctly, to 90,000 pounds. And it was said that such a statement was unwarranted. Similarly, several courts have held in cases pertaining to defamation with interesting judgments of Indian courts, of US courts, of the UK courts. In 1988, Hustler magazine, there was a parody advertisement that a person, Jerry Falwell, was doing an incestuous act with his mother. Now, that couldn't be proved. Falwell did not get entitled to damages because the court said, who is going to believe? Ultimately, it should lower your reputation in the eyes of right-thinking persons. Such a parody will not be believed. It's outrageous, it's absurd, and nobody is going to look at this. So having said all this, I want to just end where I should have actually begun, which is that India inherited this from Great Britain, and it came as a result under the Indian Penal Code in 1860. In England itself, there was a Slander of Women Act, and even at that time, where the Romans and Germans actually said that use of abusive persons against anyone would be punished with death, capital punishment. And insofar as the UK was concerned, it said that the tongue of the person making such a statement should be cut off. So, defamation is a very real remedy. Civil defamation, the tortious liability, has to be made stronger, has to be made more meaningful, has to become faster, quicker, because by the time it's decided, it is so late that people feel it was not worth their time to be litigating and to be getting their respect and reputation restored by a proof in a court of law. Criminal defamation also takes a lot of time, but however, it is still a quicker remedy. We have to ensure that both remedies continue and that the right of a person to his reputation remains sacrosanct and not to be touched or not to be interfered with on the drop of a hat, because it should have penal consequences. It should have far-reaching, tortious, civil and criminal consequences, should have injunctions, which should then result ultimately in the trial and finalization. Many political sensitive defamatory cases of defamation actually get settled out of court after a period of time, But the fact is that they do harm. The harm to a reputation may have already been done, and that's what we have to protect against. The law has gone far with K.S. Puttaswamy speaking about the right to privacy. It has gone even further steps to ensure that there is a doctrine of proportionality, and we have to ensure that the remedy is quick and immediate. Thank you.
Ma'am. We will be taking the questions which are posted on the YouTube and
I can easily take for about 15 minutes. So I'll do that.
This is by Prithman. It says, though you have explained in extent, so what is the difference between civil defamation and criminal defamation, and how it can be related once you file an SLP?
So the SLP is ultimately a consequence. See, civil defamation, you will file a remedy or you will ask for relief in a civil court depending on the pecuniary jurisdiction. And it's really a tortious right, a right in tort. Criminal defamation is a right in statute under 499 and 500. In many senses, it's got a stricter test because for the accused, because they have to not only show the truth, but they have also to show that it was for public good or in good faith, and for in terms of the exceptions under from 1 to 10, but 1, 9, and 10 being more relevant.
Ma'am, can you explain doctrine of Innuendo slightly in more details?
Sorry?
Doctrine of Innuendo, can you explain it in more details?
Innuendo. So the way to describe an innuendo is, suppose you have an advertisement, say on a billboard, which is not saying iPhone or is not saying Samsung, but is giving the features so that you know who they are talking about, and they is talking about it in a light which is defamatory or which is making imputations. What are the imputations that harm one or a company? That for a company, it will be that there's dishonesty, their product is an act of cheating, that etc., etc. See, normal, whatever may be disputes between two conglomerates fighting with each other, they will go to the company side. But if they are defamatory without naming who it is, I may name my political opponent. Without naming him, I may bring out the fact that so-and-so member of parliament who is so-and-so who has this matter pending against him, or who has made an utterance with regard to without any foundation. You know that who is it he talking about, because you've heard the utterance. So those are innuendos. And innuendo is equally, in terms of explanation also, and even in terms of law as written, had developed it, innuendo is as strong an offense or an act which is a tortious liability as a direct statement against a person.
This is, can you explain the qualified privilege in respect of statements made in judicial proceedings for defamation?
So in judicial proceedings, I think the first time that I saw that the court said even what is said in proceedings may be subject matter of defamation was in this judgment between Ram Jethmalani and I think Subramaniam Swamy by the Delhi High Court. Otherwise, I've never noticed that, in fact, courts have normally held that what is a pleading is only for the parties, and therefore it doesn't amount to defamation because you're not putting it out there for the public to read. It is in a private domain. There are some law on this, that if you make, for example, all right, let's take one thing. A person makes a defamatory statement. At the time of final arguments, will it be repeated at his instance? At the time of cross-examination in open court, is it repeated as it at his instance? So, per se, most judgments say pleadings do not result in defamation. But if you use an utterance, repeat it in a court, then it will be defamatory. And in criminal defamation, criminal complaint cases, there is a little bit of jurisprudence that is developing that even what is said in those is defamatory.
This question normally we'll have in mind. It says, what is the remedy available in false matrimonial cases where the whole family is sullied in front of the society?
So it depends. You can, if it's a criminal case, then you can file a malicious prosecution. If it is a statement made in a pleading, once you are able, for example, take an example, you do a 498 case and you bring in 10 members of the family. The police drop 8 out of the 10 accused. Those 8 accused can actually go for malicious prosecution. They can also go for defamation. So they can either file under 182 or otherwise. What do you do in false cases? This is a very vexed question because you can go for perjury, but our courts are very weak on perjury. And this actually encourages people to see whatever they want. You will never see such irresponsible statements, unsubstantiated, coming in so easily. I can't say they are not coming, but so easily in some of the courts, other courts like the UK or US, because you know you have to make good your statement. Otherwise, you will be responsible for all the costs of the proceeding, and you will get, you could get perjury. But here, perjury is because the courts are burdened. The courts don't, they normally just dispose perjury saying, let it be. But I don't think that's right. I've been seeing this from husband's side or wife's side, and or relative side, and I feel that that the courts will have to get to the bottom of the truth, whether they examine someone under order 10 and come to the truth that day only, because over time people can embellish their stories. Something should be done.
It says, what is the limitation for a malicious prosecution?
I think it's 1 year, 182, I think it's 1 year. I'm not sure, it's 1 or 2 years.
Whether the news published in the newspaper based on FIR, can it be concluded as a defamatory statement?
If it's really reporting the FIR, it's not defamatory. The courts have repeatedly held unsubstantiated allegations can be a ground of matrimonial breakup in the sense of cruelty, but an FIR till you is a first information report. Unfortunately, or fortunately, I can't say, Lalita Kumari is there that the moment you make a complaint, FIR is to be done, registered. And so normally in matrimonial cases, there is some preliminary investigation, but all the women's cells will always register a FIR, whether it's true or it's false, whether their investigation relieves it's motivated or not motivated. They may drop some people, but they will, people are adding relatives, they are adding friends, they are adding colleagues, and unfortunately, our system doesn't do anything. I think a stitch in time saves 9. If we start doing something about it, next person will be careful. But it also means one has to go an extra mile. But you can't do anything, honestly speaking, if an FIR, a true version of the FIR is reported without embellishments or additions or a story.
These were all the questions. The last question is whether civil defamation case or a criminal case is advisable. And I add more, or it can be both. What is your take on that?
So after the Arun Jaitley case, I think what seems to be more advisable is that unless somebody is keen on getting damages, because there are cases, I think in Ram Jethmalani's case, there was only a request for 1 rupee because he wanted token. So where a person really wants deterrence on a person who is wealthy and who has made absurd statements, and you want to hold him to responsibility, I would do civil defamation. Otherwise, criminal defamation is normally much, much faster. And therefore, in that sense, it's the quicker and better remedy.
Ma'am, for sharing your knowledge, and it was a pleasure connecting. That was the last question. And everyone stay safe, stay blessed. And tomorrow, friends, our session would be.
Thank you so much.
Developing advocacy skills in the arbitration by Mr. Ratan K. Singh, who is a senior advocate and a famous construction arbitration lawyer. So do stay connected with us tomorrow at 6 p.m. And thank you, ma'am, once again for sharing your insights. Thank you.
Thank you. Thank you.